The United Nations top court has found that countries that fail to take measures to prevent climate change could be in violation of international law.
In its biggest case ever, the International Court of Justice was mandated to answer two questions. The first one, what are countries obliged to do to protect the environment from greenhouse gas emissions? And the second and more controversial question, what are the legal consequences for governments when their acts, or lack of action, have harmed the climate?
The court's president said climate change was an urgent and existential threat, and states breaching their obligations to address the crisis were committing, quote, an internationally wrongful act. And that now opens the door to possible reparations over climate change.
The court concludes that the duty of states to prevent significant environmental harm applies in the context of climate change, and that this duty forms part of the most directly relevant applicable law.
You are listening to Climate Court Voices, a podcast where we speak with the individuals leading crucial climate lawsuits and championing environmental justice efforts worldwide. On July 23, 2025, the International Court of Justice ruled that protecting citizens from climate change is no longer just a moral choice, it is a legal duty. In a unanimous and unequivocal ruling, the world's highest court confirmed that states have a binding obligation under international law to mitigate the threats of a warming planet. The judges made it clear that nations must pursue their highest possible ambition to ensure collective efforts keep global warming within the critical 1.5 degrees limit. The advisory opinion arrived a decade after the 1.5 degrees target was first enshrined in the historic Paris Agreement. It marked the dawn of a more mature phase of climate litigation, one where an increasing number of cases are shifting public opinion, holding the world's biggest polluters accountable, and establishing new legal precedents. Most importantly, it serves as a final warning to governments and corporations: climate action will no longer go unnoticed. This podcast launched on the eve of the historic ICJ opinion, with the goal to document this new era of accountability, as well as the decade of tireless legal battles that made this moment possible. Today, we trace a 10-year journey with Lucy Maxwell, a climate change and human rights lawyer and the co-director of the Climate Litigation Network.
My name is Lucy Maxwell. I'm the co-director of the Climate Litigation Network. We support communities who use the law to protect our shared future. I'm based in London. I've been living here for the past decade. Originally, I'm from Australia, where I trained as a lawyer. I've worked in government and in non-profit organisations on human rights issues and human rights litigation. And I joined CLN in 2019, soon after it was created, within its first 4 years. And I've since been part of the organisation as we have grown in response to the interest from communities around the world to receive support about how to develop litigation to hold governments accountable and ensure that governments reduce emissions and protect the future of everyone on this planet.
The Climate Litigation Network was originally set up in 2015 by the Urgenda Foundation, the organisation behind a groundbreaking court case that forced the Dutch government to ramp up its emissions targets.
A Dutch court has ordered its own government to reduce greenhouse gas emissions at a faster rate than it's planning to do. A judge in The Hague said that in 5 years' time, Dutch emissions had to be 25% lower than 1990 levels. The government plans cuts of only 14 to 17%. Campaigners on behalf of hundreds of Dutch citizens had brought the case, said to be the world's first climate liability suit. The ruling said the country had to take a lead and couldn't hide behind arguments that an international response was needed.
The court's verdict essentially declares the Dutch government's climate targets illegal.
The Urgenda case was the first time a court anywhere in the world, in the Netherlands, it was a decision in the Netherlands, found that a government had a legal duty to protect people from climate change, and that meant the government needed to reduce its emissions by a lot more than it was planning to. And that decision was so inspirational to people in different countries because it showed that there were legal limits to what governments could do, and there were duties to protect people. And so from that first court decision in 2015 in the Netherlands, there began huge interest around the world to replicate that case. And people started contacting the Urgenda Foundation, which is a Dutch environmental charity that ran the case, together with almost 900 Dutch citizens. And they said to the Urgenda Foundation, how did you do this case? What science did you use? How did you use the law like this? And can we do something similar in our country? And that was why Climate Litigation Network was created, to support those communities in different countries to share the knowledge about this court case and to support their own efforts.
The Urgenda case paved the way for a global wave of rights-based climate litigation. It established, for example, that governments have a legal duty of care to protect their citizens from climate change, linking environmental obligations to human rights under the European Convention on Human Rights. Those obligations were reinforced by the European Court of Human Rights itself, when it ruled in 2024 in the Klimasenioren case that Switzerland violated the convention by failing to take sufficient action to combat climate change. And if you want to learn more about that ruling, go listen to the last episode where I speak with Elisabeth Stern, a board member of the Klimasenioren Association. Urgenda also demonstrated that courts can force governments to scale up climate action, making climate policy a legal obligation rather than just a political choice. It inspired similar lawsuits in many other nations, including Germany, Ireland, France, Belgium, and Colombia.
The Urgenda case established a number of really important legal building blocks. These are the legal rules that governments and now increasingly companies have to comply with in order to protect us and protect our future. But in terms of the structure, what we saw is that one court could develop a principle, a legal building block, that another court in another part of the world would look at and consider, we have a similar rule in our country, and we can also apply that to climate change. And so that building block would become stronger because another court would say, we're doing something similar. And what we saw is lots of different national courts make similar decisions about government's duty to protect people and to reduce emissions. And then in the last 3 years, we've seen regional courts, and they have jurisdiction over tens of governments. So in the European Council of Europe, there are more than 40 governments that are part of that regional group. And the European Court of Human Rights is the court that decides the interpretation of their human rights obligations. And that was one of the courts that said, yes, we see these building blocks that national courts have developed, and now we're going to issue our first climate change decision. And that affirmed many of those core principles that have been developed. Existing obligations under human rights law, under private law, can be applied to the problem of climate change, even though it's a global problem and it's one that everyone contributes to. Courts, and now these regional courts and the International Court of Justice last year, they have all affirmed that idea that existing legal obligations can be applied to the problem of climate change. Now, more specifically, what these courts are in agreement on when it comes to governments is that there are minimum standards that governments must meet in terms of their emissions reduction. What is now clear is that 1.5 degrees is the legal limit when it comes to the temperature increase that we must stay within. The highest court in the world last year, the International Court of Justice, in its advisory opinion, was very clear. That is the legal limit that governments have agreed to in the political annual climate process, the COPs, and that is relevant to the legal obligations under the treaties. And national courts have said something very similar. So that's one of the first minimum standards. Emissions reductions adopted by governments must make a contribution that is adequate to holding global temperature below 1.5 degrees. So governments can't just choose any old target that they want. They must show the public that that target is actually based on what science says is necessary to hold global warming below 1.5 degrees. Courts have also been clear that governments must adopt targets that are fair and ambitious. And this is very important for developed country governments in the global north, where many of these cases take place, because those governments have an outsized responsibility for the climate crisis. A number of courts, including the International Court of Justice, have found that developed country governments under the climate treaties very explicitly have accepted that they have a higher responsibility when it comes to emissions reduction. Those treaties talk about developed country governments taking the lead in emissions reduction. And those statements mean something at the national level when those governments are developing their targets. So those targets must be fair and ambitious. Two other minimum standards that courts have found. Courts around the world, I'm talking about the South Korean Constitutional Court, the highest court in South Korea, the highest court in Germany, courts in Ireland and the UK, they have all independently found that governments' climate plans must be clear, they must be specific, and emissions reductions must be spread over time. Especially in South Korea and Germany, those courts found that the governments were planning sort of vague long-term measures, and it wasn't clear that the future generations, young people alive now, wouldn't suffer the burden exclusively of all of the hard work of emissions reduction. And those courts found the government must be much clearer about its interim targets on its road to net zero, and that it's not good enough just to have some long-term vague target. The path to net zero must be very clear, because otherwise, in the short term, no action will be taken, and everyone in the future will have to bear the burden of those emissions reductions. The final minimum standard that courts have been very clear on is that targets must be implemented. That sounds very basic, but what we have found is that many targets are set and governments are often not on track to their own targets. Courts in France and Germany have found there are legal consequences if you fail to meet your own emissions reduction targets. And courts have ordered the governments to make up their efforts by adopting even more measures to protect the climate. So when it comes to government, over the past decade, national courts and then regional international courts have articulated a series of minimum obligations so that governments adopt good and robust climate measures to protect us all. In the corporate space, the legal building blocks are emerging. It's not as well developed because it's a newer area of legal accountability. But in the last 2 years, again, it's been a very important time for some legal breakthroughs. And what we anticipate is that the next decade will look quite a lot like what the past decade has looked like for governments, with, for the corporate accountability, a series of legal building blocks already established and more courts coming in to affirm that there are minimum duties that corporations must comply with, again, in order to protect the planet. Those breakthroughs in the last 2 years, one is a decision about emissions reduction obligations. That's an appeal decision in the Netherlands in the Shell case, that companies have a legal duty to reduce their emissions in order to prevent harm from their product, their fossil fuel products. That case is on appeal at the moment. The highest court in the Netherlands will hear that this year. But it was an important legal ruling there. And there's now similar cases in New Zealand, Belgium, France, Italy, that are all testing that same principle. The second legal breakthrough on corporate accountability was the legal obligation to compensate for the harm that a fossil fuel company has caused because of its products that we know contribute to the climate crisis. That was a decision in Germany in a case brought by a Peruvian farmer against a German electricity company.
Saul Luciano lawyer argued that the German firm has fueled greenhouse gas emissions and should pay to protect his hometown from a melting glacier. RWE has never operated in Peru and denied responsibility, arguing that climate change is a global issue. The court in Hamm in western Germany said an appeal is not possible, bringing the decade-long case to an end.
This is a case that's been about 10 years in the making, and in the end it was a technicality that brought it to an end. The court decided that there was not sufficient risk to the farmer's house itself. However, they did go on to say that they felt that companies like RWE should be held responsible for the emissions and the impacts that those emissions are having and causing global warming. And experts have told me that that is going to have wide-ranging consequences.
And the legal principle established there by the German court was that in principle, there was nothing to stop someone from seeking compensation against a fossil fuel company because of the harm that its products have caused. On the facts of that case, the particular location of where the plaintiff lived and the harm caused by the climate sort of induced melting of the glacier wasn't sufficiently close in proximity, like geographic proximity. But the legal principle there was very clear. And there are two new cases that have just been filed in the last few months. One against Shell in the UK by survivors of a typhoon in the Philippines, and another in Germany against RWE again, an electricity company, by flood survivors in Pakistan. So this idea of compensation for loss and damage against companies, again, that is only going to keep being tested, and we imagine the legal building blocks will only grow there as well. So there is a lot that has been created in the last decade, and now these important new doors are being opened that people are walking through.
One of the most persistent hurdles in climate litigation is the argument that these issues simply don't belong in a courtroom. For years, governments and corporations have argued that climate targets are strictly matters of politics and policy, not law. But as the legal landscape matures, we're seeing courts push back, asserting that when human rights are at stake, the law absolutely has a say. Beyond just setting targets, we're also entering a new, more complex territory, the quest for compensation. While no national court has yet forced a government to pay for climate damages, the battle against corporate polluters is intensifying, and the wall of legal defense is starting to show cracks. I asked Lucy about this shift, how courts are overcoming the political question defense, and where we stand on finally holding big polluters financially accountable for the harm they've caused.
One very common defense in the government litigation is that this question is just not suitable for courts to consider. It's just a purely political question of what targets are set, what climate action is taken. And courts have been very clear in almost every context that no, the law has something to say because the severity of the climate crisis is such that human rights are at stake here. And in many, many countries, human rights have clear legal protection. So courts have been very clear when it comes to, we have a role to play here. There are existing laws that apply, and it is not just a question of politics. There have not so far been any attempts in national courts, or no successful attempts to seek compensation from a government for climate harm. All of the cases that have been successful so far have been seeking emissions reduction activities. On the corporate side, there have been many more attempts to seek compensation from corporations for the harms that their activities have created. And I would say that area is much more nascent in terms of the legal development. Sometimes some courts have rejected those compensation requests because they say it is too difficult to assess this causal link. But in other cases, we are yet to see how courts will respond to that argument. And in the case that has gone the furthest in Germany against RWE, the court did not find that to be a barrier to the success of the case. It found that it was possible to find a causal link, in theory, between the emissions of a company and the climate impact in another country. It was just that on the facts of that case, the individual did not live close enough to the particular glacier that was likely to melt. So that was a very significant breakthrough there. And then the advisory opinion also, it wasn't asked to comment on any particular facts of one company and one climate event, of course, because it was a general statement. But the advisory opinion on causation was very clear that there is nothing unique about the situation that the law of causation can't deal with. Of course, climate change has multiple actors that all contribute to the problem, and everyone is affected. But the law has dealt with similar problems, not necessarily of exactly the same scale, but where you have multiple defendants, all responsible for polluting a river, and many people affected by that. And the law has dealt with that in terms of causation before. And the International Court of Justice said there should be no barrier to finding causation when it comes to climate change, and the legal principles there exist. So I would say this is a work in progress in terms of how now this influences the compensation cases against companies that are going through the courts at the moment. There was another important, we do talk about breakthroughs, but this is because it's such a new area. And so when one court does something for the first time, it is quite a breakthrough. And so late last year in Switzerland, There was another of these new cases trying to seek compensation from a company for its the harm caused by its products that contribute to climate change. And a Swiss court found that that case can go ahead. The company sought to block it because it was not legally possible. And the court said, no, this case can go ahead. And that case is brought by people from Indonesia against a cement company in Switzerland, which is a very profound decision for a court to see that harms can extend outside the country where a company operates, which is, of course, the reality, but it's not something that the law is necessarily that used to dealing with. And so that, again, is a very exciting development in terms of accountability. And we'll have to wait and see how that case progresses.
Winning a case in court is a historic achievement, but for the communities involved, a legal victory is only the first step. The ultimate goal isn't just a piece of paper, it's actual emissions reductions and tangible policy change. In 2023, the world watches 16 young plaintiffs in the United States won a first-of-its-kind constitutional climate trial held against Montana. The judges ruled that the state's failure to consider greenhouse gas emissions when approving fossil fuels projects violated a specific right enshrined in the Montana Constitution, the right to a clean and healthful environment. It was a seismic shift, proving that youth voices could successfully hold a subnational government accountable for the physical and mental health impacts of a warming world. However, the aftermath of that victory has revealed the sheer difficulty of enforcement. In most democracies, the rule of law suggests that even the highest levels of government are subject to judicial orders. But in Montana, the state has fought to narrow the ruling's impact, just as the Swiss government has faced international criticism for failing to implement the specific carbon budgets required by the Klimaseniorinnen ruling. This raises a profound question. What happens when a government simply refuses to listen to its own courts?
It's a profound question because at its heart is a question about the rule of law. And so in every democracy, the people hope and expect that their governments follow court orders because that is how the rule of law operates. That everyone is subject to the law, including the government. And that is exactly how democracy is protected, is by the nature of courts and their power to hold the executive accountable and ensure that it complies with the law. So if there are examples of governments not complying, I think that is concerning. And the people who've brought the cases are right to go out and publicise that and say this is a breakdown of the democratic process, because that is how it's meant to work, is that when a court gives an order, the government complies. We have not seen that as a general pattern globally following climate judgments. I would say they sit more as outlier examples. And what we have seen, for example, in Germany and the Netherlands, following successful court orders on climate change, is rapid action by those governments to increase their climate efforts. Both governments adopted tens of billions of euros in new climate funding to ensure that they met the orders and adopted stronger targets following those court decisions. In the Netherlands, there was a new climate change act that was put forward. Coal-fired power stations were closed down and a cap on coal fire was put in place. In Germany, within 2 weeks of the decision of the highest court there, they adopted a new 2040 target, brought forward their net zero target by 5 years. So those are examples of very strong action being taken as a result. In South Korea, for example, the government immediately commenced a consultation process and set up an advisory committee of scientific experts to decide what its new climate targets should be. In Ireland, there was strengthened climate legislation, carbon budgets adopted, an expert council was strengthened. So we have lots of examples of governments taking practical steps as a result of litigation. Really interestingly, in the UK, following successful challenges to fossil fuel projects, the government adopted a new policy about how fossil fuel projects should be assessed in terms of their climate impact. So I think it's something to be taken seriously where we see governments not complying. I don't think it's a trend that we're seeing globally yet, but it's something to be aware of. And it means that when communities bring cases, they need to be supported through the whole journey of litigation, because the journey does not stop when you win in court. Because of course, what everyone wants is the climate action that follows. And that's where the communities bringing cases need support and need resources to ensure that the pressure stays on so the governments deliver.
As we look towards the next 10 years, the landscape feels less like a fixed path and more like a laboratory. We are entering an era where 1.5 degrees is no longer a distant target, but a threshold we are dangerously close to crossing. This reality is forcing a new wave of legal experimentation, as communities move beyond just asking for better policies and begin demanding concrete action, whether it's carbon removal, corporate compensation, or accountability for an era of climate overshoot.
I think the story of climate litigation over the last decade is one actually of diversity and one of spontaneity. It's very hard to predict a dominant player, and that is almost what is so exciting about this, because there's a degree of trial and error. There's experimentation. Different communities and their legal teams are trying lots of different tactics because it's hard to know what will work. And the past decade has been one of experimentation. One decision from a court in the Netherlands inspired lots of different techniques in countries all around the world, in different legal systems where they didn't have the same legal rules necessarily, but the same idea of minimum standards for governments of emissions reductions was clear. So in terms of the future, I think it'll be a diversity of approaches, but the themes that will be covered are indeed government's obligations in an era of overshoot of 1.5 degrees. We are sadly a matter of 1 or 2 years away from that prospect. But what is clear is that 1.5 degrees is the legal limit that governments have signed up to. The highest court in the world is very clear on that. So what are governments' obligations to draw down emissions? What are the obligations in terms of carbon removal? And how do we ensure that 1.5 degrees is protected? I think that's going to be a huge area of legal development and experimentation. On the corporate accountability side, we will only see more building blocks develop in terms of the duty to reduce emissions and the duty to compensate for the harm caused. They are going to be huge areas of development in the next decade. And I think I'll leave it there.
We are only 2 months into the year, but the global climate litigation landscape has already seen a surge of high-stakes activity. In the United States, the judiciary has become a primary battleground for the Trump administration's energy agenda. Courts have already moved to reverse several pauses on offshore wind projects that were mandated by Trump, signaling a significant pushback against executive delays. Across the Atlantic, a district court in the Netherlands has issued a historic ruling regarding Bonaire, a special Dutch municipality in the Caribbean. The court found that the Dutch government failed to implement timely and adequate mitigation and adaptation measures, thereby violating the human rights of Bonaire's inhabitants under the European Convention on Human Rights. This case is a powerful reminder that the impacts of climate change are not just future threats, but present-day human rights violations. In France, the spotlight has turned toward corporate accountability. A court recently heard arguments in the nation's first climate lawsuit targeting the multinational oil giant TotalEnergies. The case seeks to hold the company accountable for its historical and ongoing contribution to global warming, and we're now looking towards June for what will surely be a highly anticipated verdict. We have also seen new lawsuits being filed. In Sweden, a group of young activists has launched a high-stakes legal challenge against their government, alleging that current climate targets are fundamentally inadequate and threaten their future. In the US, environmental groups were quick to file lawsuits after in February the Trump administration repealed the endangerment finding, a landmark scientific determination that has underpinned nearly 2 decades of federal emissions regulations by establishing that greenhouse gases pose a direct threat to public health and welfare. Meanwhile, on a broader European level, 2 non-profits have initiated legal action against the European Commission, challenging its decision to grant strategic status to a controversial lithium mine in northern Portugal.
There's some really important activity happening this year in terms of the government emissions reduction cases. We're expecting judgments from courts in cases against a number of European governments. So here I'm talking about the Netherlands, Spain, Austria. There's also cases when it comes to corporations' emissions reduction obligations. There'll be judgments out of France, new cases going through the courts in Italy and Switzerland and in New Zealand. And there are some important hearings coming up. In New Zealand, there's a hearing in a few months looking at the government's obligations when it comes to clear and realistic emissions reduction plans and not relying excessively on, for example, it's huge forests and unquantified, vague claims that the forest will do all the work that New Zealand needs to do when it comes to climate, in so many words. That is a very exciting case. It's one of the first to make that kind of argument globally. But what underpins it is that we want clear plans and we want realistic plans from our governments. We don't want vague promises. We want to know that we can trust our governments to take serious action that will actually work.
It is clear that the story of climate litigation has entered a new and much more rigorous chapter. We're moving past the era of first-generation cases, those that were fought simply to prove that governments have a duty to act. Today, the foundation has been laid. The question is no longer if the law applies to the climate, but how specifically it must be enforced. The future of this movement lies in the scrutiny of the how. We are seeing a global shift toward demanding transparency and scientific integrity. Communities are no longer satisfied with vague 2050 targets. They're interrogating the math of carbon sinks, the reality of fair share contributions, and the concrete short-term budgets that determine our survival. This is a move from rhetoric to realism, holding power to the high standards of the rule of law, rather than the shifting winds of political convenience. The law is finally catching up to the science. Whether it is elderly women in Switzerland or youth in South Korea, the message to the halls of power is becoming impossible to ignore. A right to a safe climate is a fundamental human right, and the courtroom is where that right will be defended. Thank you for listening, and see you next time.